All right, so I'm going to handle each motion separately. First is defendant's motion to change venue. The court has thoroughly reviewed the defendant's motion and the prosecutor's response. Pursuant to MCR 2.119E3, the court dispenses with oral argument. It's a general rule that a defendant must be tried in the county where the crime was committed. That's MCL 600.8312 and People v. Jędrzejewski, 455 Michigan 495, and that's a 1997 case. However, under MCL 762.7, a court may change venue upon good cause shown by either party. Whether to grant or deny a motion to change venue is discretionary. It may be appropriate to change venue of a criminal trial when widespread media coverage and community interest have led to actual prejudice against the defendant. That's People v. Unger, 278 Mishap 210, a 2008 case. Pretrial publicity alone is not sufficient. To establish actual prejudice, a defendant must show that the extensive, highly inflammatory pretrial publicity saturated the community to such an extent that the entire pool was tainted, or that community bias can be implied from a high percentage of the veneer who admit to disqualifying prejudice, and that's also Jędrzejewski. This would require a defendant to show that media coverage was a barrage of unrelenting, inflammatory, prejudicial coverage versus factual coverage, such that the entire community would be presumed to be exposed to and prejudiced by it. And that's People v. Delisle, 202 Mishap 658, that's a 1993 case. A change of venue might be required where there's been extensive media coverage that is so inflammatory that it leads to a pattern of deep and bitter prejudice against the defendant, or involves highly inflammatory attention to sensational details. This might include pretrial publicity that is vicious, excessive, or officially sponsored, where jurors are unable to set aside preformed notions of guilt. However, it is appropriate, even preferable, for a trial court to elect to defer determination on a request for change of venue until jury selection has been attempted in the original county. And that's People v. Porter, which is an unpublished per curiam opinion by the Court of Appeals issued in February of 1998, and People v. Muhammad, 170 Mishap 747, a 1988 matter. As a general rule, if a juror is able to set aside pre-existing knowledge and opinions about a case, that is sufficient to support denial of a motion to change venue. The mere existence of a preconceived notion as to guilt or innocence of the accused alone is insufficient to rebut a juror's presumed impartiality. To hold otherwise would establish an impossible standard. Some factors considered by the U.S. Supreme Court and lower federal courts to determine whether a change of venue is warranted include size and characteristics of the community, extent to which the government is responsible for generating the publicity, the extent to which the publicity focuses on the crime versus the defendant, whether the publicity is factual rather than inflammatory, and other factors reflecting on the public's likely effect on the impartiality of potential jurors. And that's Sarnia 157 F sub 3rd 57, a 2016 case, and United States versus Salim 151 F sub 2nd 281, a 2001 case, and also Jędrzejewski. A crime that occurred in a large, diverse metropolitan community and publicity that is largely factual, even if voluminous, weighs against a finding of presumed prejudice. Courts have found prejudice warning change of venue in very few circumstances, which generally involves some sort of confession and a small community. In United States versus Solomon, which is an unpublished opinion of the District Court for the Middle District of Florida, issued December 6, 2017, the defendant was indicted on one count of aiding and abetting a foreign terrorist organization and one count of obstruction of justice for allegedly aiding and abetting her husband in an attempt to provide support to this Islamic State of Iraq, which culminated in the mass murder of 49 and injury of 43 people at a nightclub in Orlando, Florida. The defendant moved for a change of venue due to the alleged inherent prejudice caused by the continued and constant media coverage, along with statements by the police chief, which the defendant alleged prejudiced a significant portion of the community against the defendant. Specifically, the defendant alleged that the police chief made repeated disparaging comments about her guilt, which resulted in intense and extensive prejudicial media coverage that made it impossible to impanel an impartial jury in Orlando. Factors considered by the court in determining whether pretrial publicity was so prejudicial and inflammatory as to warrant a change of venue included 1, whether the publicity contains a confession or admission by the defendant, 2, whether there was official misconduct in influencing the publicity in the case, and 3.
All right, everybody, if you're just tuning into Live Now from Fox, we wanted to kind of cut in here and let you know what you are listening into. Right now, we are live inside of a courtroom in Michigan as a judge decides whether or not to move James and Jennifer Crumbley's cases related to the Oxford High School shooting, where their son is the suspected shooter, out of Oakland County. The defense team saying that they would not get a fair trial if this happened where the shooting also took place. So we're listening in as the judge weighs in on this decision. And I also do want to let you know, to the right-hand side of your screen, one of the major opinions that we just got from the Supreme Court, them ruling in favor of a former high school football coach whose prayers at the 50-yard line drew crowds and controversy, declaring his public prayers were protected as free speech. This was a 6-3 decision and a pretty symbolic victory for those who seek a larger role for prayers and religion in the public school system, and especially in sports. So this began with the coach kneeling by himself on the 50-yard line, becoming a highly publicized event back in 2015 that drew a crowd of players and spectators on the field at the end of the game. This man, Coach Joe Kennedy, his prayers actually began as private and personal expressions and were not official acts of promoting religion at school. He was an assistant coach on a yearly contract at the Bremerton High School in Washington, where he began to pray at the end of the game. So again, the Supreme Court siding with that football coach in one of the rulings that they have just issued here within the last 20 minutes. Let's continue to listen in to this judge here in Michigan as she decides the fate of the Crumbley parents' trial. You're watching Live Now from Fox.
That jurors cannot be believed when they assert they cannot be impartial. Therefore, the motion for change of venue or veneer is denied. Our court administration has already begun making arrangements for this trial. If all counsels are amenable, I'd be interested in an in-chambers meeting with the parties and our court administration to discuss the details of jury selection. There's more than one way to do this, and I am certainly interested in your ideas and your preferences about that. So I think that there is at least one counsel here that has a vacation planned within the next week or two. But if my assistant could email you, would you be interested in getting together and talking? This is a novel thing. This doesn't happen every week, year, or decade in this county. So I think that our court administrator has reached out to other counties on other cases. So I'd be interested in sharing with you what they discovered, as well as asking you how you would like to proceed.
Yes, we're available.
Okay.
We are too, thank you. Yes, Your Honor.
Okay. All right. We will do that probably within the next 3 days. I'm very interested in moving things along. Okay. The next motion is the defendant's motion to restrict pretrial publicity. The court has thoroughly reviewed both the defendant's motion and subsequent emergency motion and the prosecutor's response to both. Pursuant to MCR 2.119E3, the court dispenses with oral argument. Defendant's motion includes complaints about statements and alleged misstatements by the prosecution in press conferences and releases. Similarly, the prosecution alleges that defense counsel themselves have circulated information about this case. Many of the alleged offending statements and evidence were made in conjunction with and at a court proceeding and are therefore permissible. Any alleged violations of the Michigan Rules of Professional Conduct are not within the jurisdiction of this court. Going forward, this court has an affirmative constitutional duty to protect the rights of the accused as well as the people. The prosecutor's brief cites Supreme Court authority for the proposition that trial publicity, even pervasive, adverse publicity, does not inevitably lead to an unfair trial, and that there is a range of curative devices available to this court to prevent publicity from infecting a jury. This matter and its various derivations have been kept in the press on a regular basis. Press conferences and internet posts by the prosecution have contributed to the attention given to this matter. However, post-charge, pre-arrest conduct by the defendants and statements by the defense attorneys have also contributed to the intense interest by the press. The prosecution points out the staggering volume of social media related to this case, both accurate and fabricated. The prosecutor's pleadings express a duty to monitor the internet so as to correct perceived inaccuracies about this case. The prosecution also expresses a duty to prevent future gun violence in what they describe as an epidemic. Although admirable goals, prevention of gun violence and correcting untruths is a desire of the prosecution, not a duty. It is not a duty of the prosecution to police the internet. An overriding duty of the prosecution, the defense, and the court is to maintain the integrity of these proceedings. Considering that a fair and impartial jury is the goal, why is it necessary for either the plaintiff or the defendant to make public statements about the case other than in open court or in court filings? The court has no intention of censuring the media. The prosecution has agreed with defendants that all parties end contact with the media and focus on resolving this case. To that end, the court grants defendants' motion to restrict pretrial publicity. Going forward, the defense is obviously able to confer with their clients, and the prosecution is permitted to confer with potential witnesses, the victim, and notify them about the progression of the case. However, any and all statements made about this case by the prosecution and its agents and the defendants and their agents will be made solely to the court, either on the record or in chambers, with all parties present, or in the form of properly filed pleadings with service on all parties. Otherwise, no statements will be made by the parties or their agents. This includes all forms of media and public domains, which includes the internet. All right.
Judge, may I briefly address the court on that matter?
Okay, briefly.
Judge, there's a reason why I think that order doesn't serve the public interest. I want to give the court one example, just one concrete example. Judge, in December, I was on vacation with my family, and someone posted on Facebook postings that, quote, exclusive, Ethan Crumbley has been deemed incompetent to stand trial for the murder of 4 students.
I'm aware of that. That was in the prosecutor's brief. I've considered that.
And Judge, that posting would have gone unresponded to for who knows how long, and victims' families saw that, and they believed that their case had been changed or compromised. In an ordinary case, the prosecutor could call their victim and say, ignore it, it's not true. We don't have that ability without the media.
You have a victims unit, right, who is in direct contact, right?
Yes.
And that is the purpose of the victims crime unit in the prosecutor's office, right? There are so many things on the internet, right? So many things. I can't allow that. I can't allow that, because then what's going to happen is then I am going to change venue. If there's internet posts and things in the media, then the prosecutor is going to be with me driving to Lord knows where, Battle Creek, St. Ignace, you name it.
Judge, I do understand that, but
Yeah.
who other than the prosecution could have corrected that statement?
It's not your job to correct the statement. It's your job to give the defense a fair trial, and that's my job too, and that's what we're going to do.
I understand, but the
Yeah.
public is misled, and we can't do a phone tree with 1,000 victims. And so we're having people who are now experiencing. So what we did in that case, I called one media outlet and said, that's 100% false. They published it and it ended the rumor. It actually got it taken down. And what I want to make sure is the clear's telling me the court's telling me I can't do that. If I see a false posting, I can't say that's false.
Correct. You cannot do that. If anyone, I am sure that there's going to be lots of disagreement with what I do today, and either side can go to the Court of Appeals. I'm not all-knowing. I'm just a circuit court judge trying to do her best, read the rules of evidence. If anyone doesn't agree with what I do, I'm sure you can go to the Court of Appeals. I'm trying to do my best, but the overriding need here is to give a fair trial to both sides and to frankly end the suffering and end some of the suffering. And the way to end some of the suffering on both sides is to try this case in the most expeditious way possible. So that's what I want to do.
I understand.
I understand why you feel that way, But this
I
is the
understand
ruling of
your
the court.
Thank you.
All right, all right, all right. Next is defendant's motion to bar or limit certain questioning. The court has thoroughly reviewed the defendant's motion and the prosecutor's response. The court dispenses with oral argument pursuant to MCR 2.119E3. The defendants have asked the court to direct the prosecution to ask appropriate questions and to cite Michigan Rule of Evidence 602. Michigan Rule of Evidence 602 states that a witness may not testify to a matter unless evidence is introduced to support a finding that the witness's personal knowledge of the matter. Evidence to prove personal knowledge may but need not consist of the witness's own testimony. In other words, a witness may testify about what they have personally seen, heard, felt, etc. There must be a foundation for the witness's personal knowledge apart from the question itself. Questioning of a witness may not assume facts not in evidence. I certainly plan on enforcing this rule of evidence. I'm going to require that a witness only testify about what they know firsthand and will only allow leading questions where permissible under the rules. But the prosecutor points out in their response that it's impossible to speculate about the questions or form of the questions that might be asked by either side. It's the obligation of the court to listen to the questions and rule on potential objections to each question as the question is asked. The next motion is defendant's motion in limine to exclude evidence that would violate hearsay and confrontation rules. The court has again thoroughly reviewed the defendant's motion and the prosecutor's response. The court waives our oral argument pursuant to MCR 2.119E3. Defendants seek to exclude the following from being presented as evidence at trial. First, the shooter's journal seized from his backpack at the scene. Second, text messages from the shooter to a friend. Third, the shooter's internet searches. In response, the prosecution seeks to admit specific statements from the shooter's journal, including the following, quote, I have access to the gun and the ammo. I want to help, but my parents don't listen to me, so I can't get any help. I have zero help for my mental problems, and it's causing me to shoot up the fucking school. My parents won't listen to me about help or a therapist, unquote. In addition, the prosecution seeks to admit statements from the shooter's journal evidencing his intent to commit the school shooting, such as, quote, the shooting is tomorrow. I'm about to shoot up the school and spend the rest of my life in prison, unquote. With regard to text messages, the prosecution seeks to admit the following from the shooter to his friend on April 5th, 2021 at 12:38 a.m. Quote, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again, but this time I'm going to tell them about the voices, unquote. And these messages authored by the shooter between 11:59 p.m. and 12:39 a.m. on April 4th and April 5th, 2021, quote, like I hear people talking to me and see someone in the distance. I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up. Like it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I'm having bad insomnia right now and paranoia. I need help. I was thinking I calling 911 too so I could get the hospital. But then my parents would be really pissed. Like I'm mentally and physically dying, unquote. And finally, the prosecution seeks to admit cell phone data showing internet searches and browsing history from the shooter. The Sixth Amendment dictates that in all criminal prosecutions, the accused shall enjoy the right to confront the witnesses against them. Michigan law prohibits the admission of hearsay unless the proposed evidence falls into a recognized exception under the Michigan Rules of Evidence. In addition, Michigan Rule of Evidence 402 indicates that relevant evidence, except what is excluded by the United States and Michigan constitutions, is admissible and irrelevant evidence is inadmissible. Evidence is relevant if it's material, that is related to any fact that is of consequence to an action, and probative, meaning has any tendency to make the existence of a fact of consequence more or less probable than it would be without the evidence. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. The court is not currently aware of any evidence that the defendants in this matter were made aware of the content of the shooter's journal, his text messages, or his internet searches. The defense argues that if the shooter does not testify in this matter and this evidence is admitted, the defense will be unable to conduct cross-examination pursuant to the Confrontation Clause and holding in Crawford v. Washington. That's 541 U.S. 36, a 2004 matter. Crawford notes that the goal of the Confrontation Clause is to ensure the reliability of evidence. To this end, Crawford prohibits testimonial evidence. The prosecution argues that the evidence they seek to admit does not violate the Confrontation Clause because it falls within several exceptions to the hearsay rule contained within the Michigan Rules of Evidence. Michigan Rule of Evidence 803 indicates that the following are not excluded by the hearsay rule, even though the declarant, in this case the shooter, is available as a witness. 803.1, present sense impression. 803.3, then existing mental, emotional, or physical condition. 803.24, other exceptions. With regard to statements in the journal, the defense argues that they are testimonial in nature because many of the passages express a desire to have the shooter's action cause a huge investigation, to become famous, to leave a legacy, and to cause President Biden to be impeached. The Michigan Rule of Evidence 803.1 exception allows statements describing or explaining an event when the statement is made at or near the time of perception of the event. The hallmarks of this exception, as noted by People v. Hendrickson, 459 Mich. 229, are reliability as judged by substantially contemporaneous and having corroboration by independent evidence. Are reliability as judged by being substantially contemporaneous and having corroboration by independent evidence. For example, the statement, "I have access to the gun and ammo," is not testimonial, is stated in the present tense.
All right, everybody, you are streaming live now from Fox. It is 10:38 a.m. here on the East Coast. If you are just tuning into our stream, we are live inside of a courtroom in Oakland County, Michigan, as a judge just declined the request to move James and Jennifer Crumbley's cases related to the Oxford High School shooting out of Oakland County. The parents are the parents of the accused shooter, Ethan Crumbley, in court right now before this judge. Defense for the pair arguing that they cannot get a fair trial in the county, but Judge Cheryl Matthews right here saying that Oakland County is not a small community, so pretrial factual media coverage isn't enough to taint the jury pool. Now, the attorneys also requested that the prosecutors be limited about what they can talk about related to the case. Judge Matthews did just approve this. It's known as a gag order. She said, quote, "Any and all statements made about this case by the prosecution or by the defendants will be made solely to the court, either in chambers or on the record." James and Jennifer Crumbley are both charged with involuntary manslaughter. They will be going to trial later this year. Now, this is all stemming from the defense arguing that prosecutor Karen McDonald tainted the jury pool by releasing certain details about the November 30th shooting that left 4 Oxford High School students dead. Since the shooting, she's held several press conferences and has spoken with the media about the case. The defense wants her to stop doing this and stop releasing information that could be used as evidence in the trial. So Judge Matthews actually just did issue a gag order saying any and all statements made about this case by the prosecution or by the defendants will be made solely to the court, either in chambers or on the record. We're going to stay in this for just a couple more minutes as the judge continues to elaborate on more of what happened on November 30th. So let's listen in live, raw, and unfiltered.
Made by the shooter during April 4th through 5th, 2021. Quote, "Like I hear people talking to me and see someone in the distance. Like it's at the point that I'm asking to go to the doctor. But I'm having bad insomnia right now and paranoia. I need help. I was thinking I calling 911 too so I could get the hospital. But then my parents would be really pissed, like I'm mentally and physically dying. Similarly, these specific texts are in reference to the shooter's current state of mind and mental issues and are admissible pursuant to MRE 8033 and the Fisher case. Text message stating, "I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up," and, quote, "my mom laughed when I told her," unquote, are also admissible. Although these texts are not specifically covered by any of the other exceptions to the hearsay rule, they are permissive under 803.24. The texts are offered as evidence that the shooter was in communication with his parents about his mental health issues. They are more probative on the issue of whether the declarant shooter made the defendants aware of his mental health challenges than any other evidence that the prosecutor may procure, and the rule and interest of justice will best be served by their admission. The texts are sufficiently reliable to be admitted. Specific excerpts from the shooter's journal and text messages requested for admission by the prosecution are clearly relevant, as they tend to make the existence of facts at issue in this case more probable. The evidence is not unfairly prejudicial and is highly probative. The shooter's non-testimonial statements about his intent, his emotional status, and describing a current event are at issue in this matter and are highly probative with regard to the defendant's alleged gross negligence. Even though texts in April of 2021 are 7 months before the shooting in November, they are highly probative of the people's allegations that the defendants continually ignored the shooter's escalating mental health issues. The prosecution also seeks to introduce highly disturbing internet searches by the shooter. The court agrees with the prosecution that the cell phone data of the shooter showing internet searches and browsing history is not hearsay. MRE 801C defines hearsay as a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Internet searches and browsing history are simply data recorded by a cell phone. They are not statements made by the declarant and are therefore not hearsay. The court is aware that it is the theory of the prosecution that the defendant should be aware of everything contained on the shooter's phone. However, the prosecution does not allege that either parent was aware of searches on the shooter's phone. Without some evidence that the defendants had knowledge of what was contained on the shooter's phone, the cell phone records are irrelevant and inadmissible pursuant to MRE 401. Last is defendant's motion to exclude irrelevant evidence. The court has thoroughly reviewed the defendant's motion and the prosecutor's response. Pursuant to MCR 2.119E3, the court dispenses with oral argument. Pursuant to MCR 2.119, I already said that, the court dispenses with oral argument. And now I'm on to Michigan Rule of Evidence 402. Evidence which is not admissible.
All right, everybody, we are going to send some of you on a quick 2-minute commercial break, but if you are just tuning into our stream, wanted to let you know that we are listening in live as a judge in this Oakland County, Michigan courtroom has officially declined the request to move James and Jennifer Crumbley's case related to the Oxford High School shooting that happened back in November out of Oakland County. The parents are those of the accused shooter, Ethan Crumbley, sitting in court before this judge, whose name is Judge Cheryl Matthews. The defense for the pair have argued that they will not get a fair trial in this county. However, Judge Matthews said that Oakland County is not a small community, so pretrial factual media coverage isn't enough to taint the jury pool. The attorneys also requested that the prosecutors be limited about what they can talk about related to the case. The judge did approve this, saying that any and all statements made about this case by the prosecution or by the defendants will be made solely in the court, either in chambers or on the record. Now, James and Jennifer Crumbley are both charged with involuntary manslaughter. They'll be going to trial later this year.